All right, welcome back. Let's get this day started with a panel that really takes on some of the most cutting edge issues in the securities enforcement world right now. SPACs, climate issues, ESG, they're all major priorities for the SEC, and this panel will break down where things stand. And let me first introduce our moderator, Kaz Hashemi. Kaz is the chair of the litigation department at Wilson Sonsini, and he has represented companies and boards in more than 100 SEC and government and internal investigations during his career. Kaz is also a veteran himself of the SEC Enforcement Division. He's now practiced at Wilson Sonsini for almost 15 years and has built a global, multifaceted SEC enforcement practice. And always great to have Kaz with us. Welcome, Kaz.
Thanks, Bruce.
Next, let me introduce Doug Davison, a partner at Linklaters. Doug has over 20 years of experience advising individuals and entities in proceedings involving the SEC, the DOJ, FINRA, you name it. He previously served as counsel to former SEC Chairman Levitt, and also as a staff attorney and a branch chief in the SEC's Division of Enforcement. Welcome, Doug.
Thanks so much, Bruce.
Good to see you. Also very pleased to welcome our guest from the SEC, Associate Director Melissa Hodgman. Since 2008, Melissa has rocketed through the SEC ranks to take on her current senior position, where she leads many of the SEC's most prominent enforcement matters into financial fraud and many other matters, including the ones we'll be talking about today. It's always fantastic to have Melissa join us at these events. So thank you and welcome, Melissa.
Good morning, Bruce.
And finally, very pleased to welcome Jay Spinella. He's a senior managing director at FTI Consulting. He is a CPA with more than 18 years of accounting experience gained in Big Four public accounting and with the SEC, where he served in the SEC's Division of Corporation Finance. Jay, thanks so much for joining us. Welcome.
Great to be here.
All right, let me turn it over to Kaz.
Thank you, Bruce, and hello to all of you, bright and early from California. Actually, it's dark here, but I have my cup of coffee and I'm ready to go. We have a great first panel where we plan to discuss some emerging topics, as Bruce mentioned, and creativity and advancement in financial technology and communication spaces is generally good, but it also gets the attention of regulators sometimes. And the emergence of SPACs appears to have received the attention of one regulator in particular, the SEC. We've also seen the impact of climate change in our everyday lives throughout various industries and the ways in which companies have begun to address and comment on environmental issues or ESG matters. That has also received the SEC's attention. And as the landscape for doing business shifts and our environment presents new challenges, the regulatory enforcement fields adjust to meet the circumstances. So we're going to discuss a number of topics that highlight these points and raise issues of first impression in some ways: SPACs, ESG matters, and a few other emerging enforcement priorities, including some changes to the Wells process, the SEC's focus on remedies, and 10b5-1 plans. Each of these brings interesting and novel issues, and we have an excellent panel to dig into it. And first, we'll start with SPACs. In some ways, last year was the year of the special purpose acquisition company. As folks know, a SPAC is a company with no operations that registers the offer and sale of securities for cash, puts it offering proceeds into a trust or escrow for future use in acquiring a private company. The business combination with that private company is the so-called de-SPAC transaction, and the combined entity carries itself as a public company moving forward. In the last year, we've seen a bit of guidance and statements coming out of the SEC on the issues related to SPAC. In December 2020, Corp Fin told us and SPACs to carefully consider disclosure obligations as they relate to conflicts of interest, potentially differing economic interests of the SPAC sponsors and directors and officers. Then in March 2021, Corp Fin issued a statement discussing the books and records provisions and internal control requirements for the SPAC before the business combination and to the combined entity after the de-SPAC transaction. And then in April, the then acting director of Corp Fin provided a statement on SPACs, de-SPACs, and liability and the applicability of the federal securities laws to the de-SPAC transaction, which, as he referenced, was the real IPO. So with that background, no offense to Doug and Jay, our star of this panel is Melissa. So before we get to an actual enforcement action, Melissa, if you could provide your thoughts on some of those statements and guidance that came out of the SEC and the heightened focus on SPACs and de-SPAC, I think our audience would benefit from that perspective.
Thank you, Kaz. As you probably anticipate, first I'm going to say whatever I say is my responsibility, and you can't hold anyone else at the commission responsible for it. So, good morning. SPACs exploded onto the scene, and as often is the case, the commission has to go where investors are going, where the marketplace is headed. What we end up focused on, and we are very intentional in trying to give clear guidance and messaging to the industry as a new area becomes of interest to investors. This looks a lot to me like reverse mergers a decade ago, or some of the other capital formation approaches that we've seen. And I think what you're going to see with regard to the guidance and then any cases coming out of the area is similar, that we'll be looking at our longstanding principles with regard to disclosure and making sure investors have the information that they need, and that there's not fraud in the marketplace or people trying to take advantage of investors. Unfortunately, when something becomes hot, that tends to also draw in some of the bad actors. And so we're, as Gary has said, the cop on the beat with regard to making sure that any issues that arise in that area are taken care of.
Was there anything in particular about SPACs that you think triggered the number of statements coming out of the SEC that got attention?
Yeah, what I would say is the disclosure in this area starts out with a blank check company. Somebody, you don't know what you're investing in at that point in time. And so there are some things built into the process that allow investors to make a decision at the end whether or not they want to stay invested. But there's also pipe investments along the way, and those investors don't always have the ability to then decide not to participate in the ultimate acquisition that occurs. Banks aren't involved in the same way to do some of the due diligence and disclosure. So this is a process that, it's very important for us to make sure that investors have full information all the way through the process, from the SPAC through the pipe to the de-SPAC transaction.
So as a message to investors, be careful, and also to the people involved in the SPAC transactions, be careful. Doug, from a defense perspective, what are some of your key takeaways from the statements and guidance before we get to an actual enforcement action that was coming out of the SEC over the last 12 months?
Thanks. So I think be careful, obviously, but there's been such hyperactive focus on this area that I'm sure Melissa appreciates this. The defense bar has become an important part of making sure, I think, the comment letter process and what ends up being a disclosure is what you would want. I think the challenge has been for all of the market participants in the process that everybody's so nervous because of what you just described has been coming out of the commission. It's really slowed things down. It has, I think, put people on high alert, thinking that maybe enforcement is sitting with the reviewer in Corp Fin, literally just giving questions because the questions may be repetitive. So I think but maybe that's good. It's certainly frustrating to clients, but from my perspective, not going to surprise you, the advice is, if they're asking you to disclose it, tell me why you can't disclose that. And I think most clients are willing to do it, but it's really become a very difficult process, I think, just because of the heightened scrutiny. I will ask Melissa if it's kind of like in some of the periods where the exam staff was very quick to make referrals, what the level of communication is between Corp Fin and enforcement on some of these, the review process right now. I'd be interested in what she would say.
So my answer is we're always in close coordination with our sister operating divisions. I wouldn't say that SPACs has changed that, but the coordination is very tight. The other thing is this is a marketplace in which we have whistleblowers, we have very active investors, and so our sources of information are numerous, and that hasn't changed. It's only increased over time.
Doug, have you, in the last 12 months, have you seen a different way you speak to SPACs and advice you give in light of the guidance and activity from the commission in this area?
Well, I haven't really advised SPACs before the past, COVID period. I have to admit, I mean, the blank check boom, I remember that years ago, but SPACs had never really been something I'd focused on. So yes, I mean, I think a lot of the players are sophisticated, but not all of them.
Mhm.
And so I think there is a level of education required about here is the process. If you do that, here's what I will expect will happen. If we go the other way, this might be better. So I think there's a lot of counseling, and it's obviously not just from enforcement folks, it's from the folks that do the offering work day to day. But I do think I'd be interested in what you say, Kaz. I think we are getting pulled in, we being the SEC enforcement types, pulled in earlier, which is good.
Right.
Before there's a problem, to kind of have a dialogue with the client about potential risks.
Right. Yeah, I think that's right. And what about there's been a lot of talk about the target's readiness to be a public company. I don't know if Doug or Jay want to kind of comment on that as you observe these SPACs and the de-SPAC transactions, and they're about to become a public company with all the responsibilities that come with that and the application of certain provisions of the federal securities laws that come with that.
Jay,
Yeah, I'm happy to jump in here. I think it's clearly the commission is focused, and for good reason. With the SPAC targets, I think the interesting thing is companies that were maybe 12 months ago thinking about an IPO that was 5 to 7 years down the road are now potentially pulling together a registration statement for a potential de-SPAC merger. And maybe they're not quite there from an accounting and finance maturity perspective. So things like internal control documentation, accounting policies, accounting and finance governance, audit committees, disclosure committees, those things are still maturing, and that just enhances the risk profile. So that's not to say these de-SPAC targets aren't ready, but they need to be thinking about all of these different things that maybe they had 3 to 5 to 7 years previously to get that kind of infrastructure set up from an accounting and finance perspective. And even something as simple as, potentially accounting and finance org design. Are these companies staffed adequately to be ready to be a public company, even post de-SPAC merger? So I think from an accounting practitioner perspective, there's definitely a lot to think about.
And have you found yourself, when you're talking to a client, pointing to some of the statements coming out of the SEC and trying to make your point on that? Some of the points, some of the items I just raised. Hey, did you just see that the acting director of Corp Fin said X about a de-SPAC and the internal controls provisions and the books and records?
Yeah, it's a constant discussion, and I think it's one of those discussion points that folks, they're living potentially a transaction, and so there's a lot going on. But clearly it's a focus area, and the disclosures and everything that comes with being a public company is clearly a focus area. But I think overall, there's somewhat of a struggle to get up to speed from all that kind of nuts and bolts accounting and finance organization, and ultimately, I feel like from the perspective of advising companies, it's my advice is always, if you're feeling like things are moving too fast, slow it down, get it right.
Yeah, and Doug, I don't know about you, but I do think the statements coming out of the SEC and the guidance has an impact, a practical impact. So I think it's succeeding in in getting a message across through these guidance and statements.
I agree. I feel like I'm just thinking about projections, conflicts of interest, the focus on risk factors. If anything comes up, I feel you can find some recent statement by Chair Gensler or Corp Fin or anybody, pointing to how people need to focus on that. And as Jay said, get it right. So I don't know. I do feel like there's so much coming out of the commission now. There's a lot of priorities. And I bet Melissa feels that way too. But on this one, the good news is you can find, I think, as you're advising clients, things that are helpful to point to.
Right.
And Kaz, I know the other thing we can point to is some of the parallel litigation.
Yeah, that's what
that
I'm going to
we've
go
seen
to
too.
next.
Yeah.
Enforcement has spoken in the way they like to speak.
Right.
That's to an enforcement action. So
Yeah.
why don't we go to that next? And in April, as all of you may know, is the brought in enforcement action against the SPAC Stable Road, its sponsor, its CEO, the SPAC's proposed merger target, Momentus, which was an early stage space transportation company, and Momentus founder and former CEO. For false statements about the technology of Momentus and the national security risk related to its founder and CEO. Before we address the remedies, Melissa, it'd be great, and I know you had a quote in the release related to this, about your perspective on the underlying case, and we'll get to the remedies after that, but kind of hit every element of this. So turn it over to you to talk about that case a little bit.
Yeah, I think Momentous is a great case to focus on. Once you've had guidance out there, if people aren't following it, Momentous hits, I think, on everything. We'll talk about the remedies, but the point here was that the disclosure wasn't good. The message wasn't received or followed with regard to what the commission was trying to highlight in order to keep people out of trouble. But this is within the entire life cycle of this SPAC. There were issues that were raised, and all of the parties are unfortunately a part of our resolution or our litigated action with regard to the management. But you saw the SPAC sponsor, you saw the management of the SPAC, but you also saw the target and their management involved in this case. And unfortunately, each one failed to take certain steps with regard to disclosure of key information. Another area of focus here was the due diligence that the SPAC needs to be undertaking and the questions that they need to ask. Those responsibilities, as Jay noted, and I think Doug also mentioned, are these companies ready to be public companies? Are they taking the steps that they need in order to make sure that the information they're able to provide is sufficient? We have other cases that touch on projections, but this case, I think, hit on almost all of the issues that are of concern to us as we're going forward.
And then I'm going to get to Doug and Jay in a second, but walk us through the range of remedies. There was a little bit of everything in this one.
Yeah. The goal throughout is to make sure that investors have the information that they need in order to make an investment decision. And so the remedies were designed to align the interests of each actor, all four groups, with the investors, and making sure that everybody had the information they needed, and when they didn't, to put them back in a position to make those decisions. The sponsors, we felt, had to take responsibility for their failures with regard to some of the due diligence and some of the disclosure that had been put forward. We wanted to make sure that the PIPE investors who had not been given full information when money was raised for them had an opportunity to make an investment decision based on full information. So we collected money that can be sent back to them in order to put them back into the position that they should have been in the first place. And then obviously we wanted enough disclosure out there that the investors in the SPAC itself could make the decision. Did they want to continue with the investigation, or did they want to pull out? And I believe about 60% actually pulled out. The transaction did go forward on full information, and that's the way the market should work. So the remedies were intended to align interests and make sure that people could be made whole if they had invested without full information.
And it also had an undertaking associated with a compliance consultant, a monitor. Can you talk about that a little bit as well, that the commission felt it necessary to keep an eye on this for the next 2 years through an independent monitor?
This is part of whether or not a company is ready and giving the disclosures that they need, and has set up the situation so that investors are getting the full information and the marketplace is getting the full information that they need to be a public company. As Gurbir and Sanjay spoke about, our director and deputy director during SEC Speaks, we're looking at every form of remedy. And this is another example where we think that beyond economic remedies, there are things that are necessary in order to protect investors in a forward-looking kind of way.
Jay, Doug, thoughts on this case and how it impacted you and how you interacted with clients?
Jay, you want to go first?
Yeah, I'm happy to jump in. I think the diligence topic is an interesting one. It sort of liaises with the point around public company readiness. In a typical diligence, you're talking about financial diligence, but also in these situations, given that these might be relatively immature companies, you may be talking about product viability, technology, financial systems diligence, again, internal control diligence. There's sort of this aspect, I think, with given this enhanced or more compressed time frame in identifying a SPAC target, it just puts additional pressure. There's almost this sort of fear of missing out on a target and rushing diligence. Clearly, diligence is vitally important here and almost enhanced diligence. And I think kind of that public company readiness aspect of it should be part of the diligence as well, which is important.
I would just add quickly, because I know we need to move on, that Melissa said all parties were named, and most of the parties were named. So to me, that's really important. The poster child for the story that enforcement will look at everybody in the context of this transaction and carefully assess each party's level of diligence. And to me, that was the most important part of this.
Yeah. Any other cases catch your attention in this field, Doug?
You give me a chance to say the word Akazu. Yes, that one did, just because of the name. But we should move on so we don't run out of time.
Okay. So I'm going to just briefly touch on something and not save Melissa from this topic. The U.S. House Committee on Financial Services released a draft legislation that would amend the 33 and 34 Act to exclude all SPACs from the safe harbor for forward-looking statements. Doug, if it passes, how will this impact the way companies approach disclosures, particularly projections and forward-looking statements, you think?
I think difficult to predict. Possible that maybe there's a reduced flow of information, maybe, to investors. But even without that, I think people will always have liability for actual knowledge of false, materially false statements. So I'm not sure if it passes, and that's a big if, whether it would have a real impact or not. In our world, obviously not so much.
I can't leave this topic, Melissa, without asking a question of how much more activity and enforcement actions do you anticipate in the SPAC space? And a numeric number would be preferable. By that.
You're not getting an answer to that question. Unfortunately, my business is driven by the decision making of parties outside of the SEC. So it will depend on how good the due diligence, disclosure, and projections, et cetera, of all of the parties within the transactions are.
Yeah, I think from the defense side, though, we're expecting more activity. So let's go to our next topic, ESG. Climate and environmental, social, and governance matters are, of course, an incredibly important issue for all of us in our lives. But the SEC, as well, is turning its attention in this direction, created a task force, the ESG task force, earlier this year. So, Melissa, turn it over to you to talk about the task force, policy considerations behind putting the task force together and what they're doing, and we'll go from there.
So the SEC is routinely focused on the things that are important to investors in boardrooms, to the market, and climate and human capital and other issues have become increasingly important in terms of the risk that they pose to the bottom line of entities, also to the products that are out there that are tied to those topics. And so as those have become areas of focus and areas of risk or importance to investors and entities in the marketplace, we've focused on those increasingly. And so we're applying longstanding principles with regard to disclosure and making sure that investors, again, have the information that they need in the marketplace and that it's accurate and fulsome. And so we had a task force created and led by Kelly Gibson, who was acting deputy at the time and continues to lead it as the head of our Philly office. And they're focused on those issues, making sure that what is being said in the marketplace matches what is actually happening in the real world. It's a cross-divisional staffed task force, but we also are working in close collaboration with the offices and divisions in the commission.
We haven't seen any enforcement activity yet. Are you able to elaborate on the plan with respect to the task force and enforcement interest in this area?
I think it's going to be a similar answer to what I gave with regard to specs. As necessary, you will see enforcement actions. This is certainly an area in which we are focusing resources. And whenever we focus resources in an area, I think it's because we're seeing or having concerns with regard to it. And it's something that's important to investors.
Jay, how are companies thinking through the impact of ESG related issues? This task force, can you give your perspective from?
Yeah, I can jump in from an accounting practitioner perspective. I think people are aware of the guidance that's come out from the SEC on ESG related disclosures. But I think overall, I think for accountants, it's still somewhat of an abstract concept. They're trying to figure out how is this going to impact my financial statements, my financial disclosures. Clearly, MD&A is an area of focus. There's been guidance from the SEC. We understand there's been some letters out from the commission to companies around impacts involving MD&A. I think accountants, in theory, they tend to think, like myself, tend to think about prescriptive guidance. So I think overall, accountants are hungrier for some additional framework or guidance on how these ESG disclosures should impact their core financials, maybe outside, if at all, outside of the MD&A, which is clearly a focus area. So I think people are taking this seriously, looking to see what additional guidance comes out of the SEC and to see what others are doing. So clearly a focus area, but I think accounting practitioners are looking for a bit more on how it's going to impact them.
Doug, from a lawyer's perspective, not too abstract, it's whether a false statement was made.
Right.
And what are you thinking about as you talk to clients, as this becomes a area where enforcement is putting resources into, and as Melissa said, when enforcement put resources into something, it usually results in some form of an enforcement action at some point. So how are you thinking through this, and what kind of issues are coming up in your discussions with companies and clients?
I think Chairman Gensler said that, you have to be able to look under the hood of the funds when they're saying these things. I think making sure clients are walking the talk, and that there's a connection that's real between what they say they're doing and what they're doing, and it's evidenced by policies, procedures, and meaningful compliance oversight. I think a few weeks ago when there was news that the SEC, DOJ, and BaFin were looking at one of the investment advisors' statements about sustainability, that caught the attention of a lot of clients. But I was pleasantly surprised that when talking to them, they said, "Yeah, we've been following this closely, making sure we're connected." Didn't say if they were connected, but I think everybody's aware of it, and I'm sure there will be cases where everybody hasn't gotten it perfect. But I do think that, again, this is an area where there's been so much commentary and activity, and task forces are great, but I worry that a task force only measures itself by the cases it brings, not by the cases it doesn't bring. So I'm sure we'll see some cases. That's what I heard from Melissa.
Is your concern that the enforcement staff will take maybe an aggressive stance with a disclosure to make the point?
No, why? Come on, never. But I mean, I worry that with a task force, cases that might otherwise have been addressed in whatever manner, things may be ratcheted up a little bit.
Yeah,
I do worry about that, particularly given the other developments we're going to talk about.
Right. Well, let's move on to that. I think the last topic we have, and it looks like we've got about 14 minutes left, is emerging enforcement priorities. And in our session when we were talking before, some of the things coming out, some of our other panels are going to cover today: cybersecurity, crypto. But let's talk about something that came out recently at the SEC Speaks conference, the Wells process, which obviously Doug and I participate in. the director of enforcement and the deputy director of enforcement suggested the SEC is going to streamline the wells process. In particular, going forward, they may not participate in every wells meeting, and associate directors and unit chiefs will handle many wells meetings with the staff who are on the ground and closest to the issues, as they stated. Also discussed was the view that pre-wells white paper submissions have gone beyond their intended purpose of addressing, significant factual legal issues and are often duplicative of later well submissions. So the front office will defer to the staff, the frontline staff, to determine whether to accept white papers or simply issue a wells notice. That got our attention. So tell us about these recent changes, Melissa, from your view. How do you think this impacts the process and the benefits you see, perhaps?
Yeah, I don't know that it's as new as people are feeling it to be. I do think there was a long period of time where this was exactly the way the process ran. And those closest to the case are the people who are most well suited in order to make some of these determinations. Part of, I think, what was happening is the process was coming to be extraordinarily long. You could have processes that last 6 months to a year, which isn't in anyone's interest. And I think a lot of the focus here is in order for us to be more effective, more efficient, and to keep things and cases moving, using those that are closest to the facts. And, our staff is tremendously sophisticated and just tremendous attorneys and able to do this work so that everyone can kind of benefit from that process. I think that Sanjay and Gurbir will be involved when there are particular issues, something that is new, something that is particularly programmatically important for the commission. But generally speaking, I think this is going to be in everyone's interest because things will move more quickly, and that's good for the bar, that's good for your clients, and that's definitely good for the commission.
Doug, is it good for your clients?
So I guess we're worried that that means that people most invested in the case may not come to some of the arguments with an open mind. But I'd like to flip the script, Melissa, because I agree with you, and we talked about this. If the idea is to kind of get, to the meat of the matter sooner, we love reverse proffers. We love to engage in that process. It's difficult and of course it's understandable in an early investigation when you say, well, what can you tell me about this matter that, they're learning. But at some point, the staff can share, and it's a two-way road. I understand you got to have kind of trust on both sides, but maybe that can be, I think you have a practice of sharing, trying to reach. It may be that you never get to the Wells notice because you've had a dialogue and you've actually achieved the purpose that we all want, which is, in some cases, quick resolution. So I guess I wonder if that could be part of the dialogue instead of I think people here, we're not going to let you appeal things when these statements are made. And that's probably not what is intended. It sounds like what's intended is we want to expedite it, which is great. Let's expedite it at all levels and not just at the end.
I agree. It's definitely, though, a relationship of trust. And so, unfortunately, one of the other things that we've seen and one of the things that Gurbir and Sanjay were addressing is, attorneys as gatekeepers and as attorneys as part of this enforcement process. And so as long as attorneys are playing that role in a healthy way, I think a dialogue is exactly how we get to resolution. The benefit of the Wells process is often that we're testing our theories. We're public servants at the end of the day, and we represent you and your clients as well as the other investors in the marketplace. And so making sure we get to the right answer is always the goal and something that our staff does routinely. It's not pure advocacy around here. And so I'm not concerned about not getting a fair hearing. Certainly as an associate, I will be in the process and, able to evaluate across the work that we're doing, not just one team, but my teams get it right. I am absolutely impressed with the work that they do. And as long as everyone's behaving well in the system and, able to trust each other, as you noted. I think there's a lot of information flowing both ways. We get it right, and we do that by being open and discussing when appropriate what we have and the questions we have.
Can we appeal all our cases to you? I'm just kidding. All right.
How about the two? I saw a comment about the 2 weeks. That's sometimes pretty tight for Wells submissions are sophisticated submissions sometimes that you marshaling evidence, documents, testimony. As Doug suggested, if you start with the reverse proffer earlier, could have a more productive work product, whether it's a white paper or a submission. How tight are you going to be on that 2 weeks if we're in that?
When we get to a Wells, it's pretty clear that that's where we're headed. I think that there is plenty of notice and ability to get those submissions. We know what the facts are. We've been discussing them. The issues have been joined. And so I think generally 2 weeks should be sufficient. This is about everybody's best interest in moving to a resolution, if we're going to move to a resolution, or moving to a litigation, if that's where we're headed in the Wells process.
How about 4
and
weeks?
if we get to Wells...
Come on,
I like
3
to.
weeks. We can talk about it maybe afterwards. All right. So another thing the staff has been talking about, and the director, is more, quote, aggressive, end quote, use of available remedies and enforcement actions, including, using officer and director bars, monitors, undertakings, and then admissions. We'll get to that. So Melissa, please give us your thoughts on the statements from the director regarding broader scope of remedies being used moving forward, perhaps.
Yeah, I think it reflects what's needed in the market at this point in time. We see recidivism, we see egregious behavior, we see repeated misconduct in areas. And so the purpose of some of our remedies is deterrence. In order for deterrence to be effective, we have to have individuals present. We have to have penalties of an appropriate size. And this is in addition to disgorgement and getting ill-gotten gains back to people whenever we can. But often it's the ICs or the undertakings or the additional steps that are intended in a forward-looking way. For example, in the Sable Road case, to encourage compliance so that we don't see people again. Recidivism is something we should not have in the marketplace if we're scaling our remedies the right way. And I think the approach that Gabir and Sanjay are recommending is intended towards that end.
Doug, how do these additional statements about remedies impact your calculus from a defense side as you're navigating a client through an investigation that is going to have some kind of potential enforcement action associated with it?
So when Melissa explains it, it all sounds quite reasonable. The one area that worries me is the area of admissions, which was hot years ago. And I think the devil is in the details. And Melissa maybe said that the other day, I'm not sure. But I think how it plays out, what is an egregious case for us? There's so many potential collateral consequences for clients, whether it's not just limited to potentially parallel class action, DOJ activity, whether it's in view or not, debarment, other regulators. There's a lot, and I know the devil will be in the details, but I think having some sense at some point, rather than just seeing enforcement cases come out early on about what is it, what admissions, and that just, I think, sends a shiver down the backs, because I think people are worried that it will be much more difficult to achieve a resolution, and clients may just say, we'll roll the dice. But that may be okay for the SEC. I don't know. So I wonder, Melissa, what would you say about the admissions? What can you say about that?
I think that Gabir and Sanjay have been pretty clear about why we need admissions and where we need them. I think it plays into what I was just saying about not seeing recidivism, not having things happen again that shouldn't happen again, deterrence, the types of things that are in everybody's best interests. When we get to a case that's about admissions, it's because it is egregious. You have recidivism, you have harm to a tremendous number of people in the marketplace. It's something that was avoidable and yet it was still done. It's a case where the evidence is so clear, or a case where there's criminal case involved, that admissions are appropriate in those circumstances. And if it sends a shiver down the spine, it may be in those cases that shiver is very, very appropriate, because we don't need to be seeing the type of cases in which we need admission.
Could you see the circumstance where the commission seeks an admission where there is no parallel criminal case?
Yes, I think that's exactly what Sanjay and Gurbir were saying, and we do have cases like that. We have had cases like that. I think there were 80 cases during Mary Jo White's term. Not all of those involved criminal cases. There have been cases during the last administration where we had admissions that didn't involve criminal cases. They are the cases where admissions are appropriate, and I don't think they'll be surprising which cases those are. And just as we're looking globally at the package of remedies, I think no one will be surprised by the cases where that's required.
Doug, how does that change an individual? There's no criminal case going on and the commission is seeking an admission. Have they just invited a criminal case?
Yeah, that will be the worry. That could extend the our efforts to come to some quick resolution. I worry if in those cases, but maybe, I have to give some thought as to where it went. Think about what Melissa said about really egregious stuff, things that wouldn't surprise us. I don't know, to give some thought to where that could happen with an individual. Maybe insider trading case that just as insider trading we don't think is egregious, the SEC does, and then we're going to be stuck with some potential admission out there for DOJ to use.
Right. It's trying to think of the case where it's egregious for the SEC case. There's no parallel criminal case that you're aware of, and then that admission then triggers that.
I think a lot of cases are viewed by the SEC as egregious. I worry. So maybe they particularly egregious. Need another description for it. I don't know.
Is that the Doug Davison standard?
I don't know. I'm trying to flip the script on this one.
Particularly egregious. All right. It looks like we got 2 minutes left. 10b5-1 plans. The chair obviously has spoken on this topic. I'm not going to review the statements he had in the interest of time. Can you just give us, Melissa, bring us home in the last 30, 40 seconds on some thoughts on 10b5-1 plans?
Yeah, I hope it's a topic that's covered later. This is an area of particular interest to our chair. I think that he's articulated some of the problems in this area, the lack of, a period of time between the decision and the actual trading. These can be buyback cases where it's the company itself trading with their own shareholders. And so this is an area where I would also point to the bar and the gatekeeper point that Gurbir made in his speech. There's advice sought in this area. This is an area where people could get themselves into trouble. We know what material is and material non-public information is. And so that's going to be something that we'll be looking at going forward.
Melissa, thank you so much for all your insights. Really appreciated. Doug and Jay, you were wonderful as well. Bruce, back to you.
Thanks, Kaz. Hey, Jay, Melissa, Doug, thank you so much for getting us off to such a great start this morning. And thanks for getting up so early on the West Coast, Kaz. Appreciate it. All right. Our next panel is in 5 minutes at 9:20. It's a great panel on cybersecurity. We'll see you back here in 5 minutes.